Hello everyone and welcome to my YouTube channel. So I'll be picking up quickly from the very last class I had on the formation of business organization. So that's kind of the chapter 2 of the ICAN business law exam. Yeah, if you have not been following this series, you can actually check out my playlist to see where I kind of summarized and reviewed the ICAN study pack. Yeah, say please subscribe to my channel, comment on it, on how it has helped you. Also like on it just so others can see the video and it will be also helpful to them. Now let's just get right in. When we talk about the registration of business name, we need to first know what business name is all about. Business name is just referring to the name or style under which a business is carried on. So when we are talking of business name, we are asking ourselves what is the style of the business? Is it proprietorship, sole proprietorship, partnership, or whatever? Yeah. And Kama actually made the reservations on when to register a business name and when not to register a business name. Kama said in its act that where the business is a firm, yeah, when it is a firm and the name that they want to register is not the true surname of, let's say for instance, the partner now in a partnership business, then we can actually and must um register it. Let me take it again. When it is a firm and the name which they want to register is not the true surnames or initials of the partner, then they must register it. Yeah, in the case of an individual, when the name does not consist of his or her true surname or initials, then you must register it. Likewise company, right? But one thing I was saying this is that when you're actually sending out your documents to the registrar of business name, they'll require that you add your true surnames, yeah, or any previous um previous surnames you have. So that's part of the requirements for the registration process. So when they check it and they see that the name that you stated there is your true surname, then they might refer back to you and tell you that it's not necessary for you to carry out the business and register the name because your proposed business name is your true surname. I hope I'm making sense. So what I'm trying to say in essence is that if what you want to register as a business name, let me paint a scenario now. My name is Emere Michael, yeah, and then I'm starting up a business in my true surname. The business is bearing, let's say, Emere Michael, no other thing, just Emere Michael. Then I don't need to register it. But if it is bearing Emere Michael and co, you see that addition, it will make me and prompt me to register it. You get. So I think I've done justice to that explanation. Yeah. And there are procedures for the registration. Like I said, you need to submit to the registry, yeah, of business name within 28 days of commencement of business. So when you actually commence business, under 28 days, you need to submit to the registry the name, your proposed name, the nature of the business, the address of that business, yeah, any other branch address that you may have, and your present four names, that's your first name and your middle name, and then your surname also is required. Yeah, so yeah, you can just check out the remaining part of the process. Now you know that the effect of so when you actually fulfill all that has been stated of you to do, then they will now effect your name in the business name registry and issue you a certificate. Okay, and there are distinctions between a partnership and a company. When I was going through this whole thing, I noticed that they when they were trying to differentiate them, they were making this except limited liability partnership. You get, because there are two types of partnership. Like I mentioned in my previous video, there is general partnership and you can also have limited liability partnership, limited partnership. So it's more or less saying that in general partnership, based on liability, all the partners are liable for any debts incurred or liable for any obligations of that business. But for limited liability partnership, they are limited to some point. Yeah, distinction is based on membership. Let me start with that. But based on membership, a limited partnership is just, if it's not cooperative society or a law firm or people practicing accounting, it's limited to 20 persons maximum. But for company, except private company, is limited to 50, and for public company it is unlimited. You get? So, and based on it being a legal entity, a general partnership is not a legal entity except for limited liability partnership. So therefore, if a person dies, for instance, now in partnership, general partnership, it can actually close down the business. You get? So sorry, my explanation here is on the part of perpetual succession. Sorry, it was on perpetual succession. I've corrected myself on that. Okay, so you could actually check out the explanation or more detail on the differences between partnership and company, the distinction between them. There are not much distinction between them. Yeah, there are not much, particularly for limited liability partnership and company, but there are very much more distinction for general partnership. So I just have to point it out there. So let's move on to company. When we talk about company, we're talking about an association of persons, which is registered as a separate person from its members, and it's not by name. Now on this part, we are made to know that a company is a legal entity. You get? It is separate from its members or separate from its owners. It is a legal entity. Okay, let's move on straight to the Corporate Affairs Commission. Now the Corporate Affairs Commission, I take it as the policing body that ensures the administration of karma fully for companies. I take it in my own word. I take it as a policing body that ensures the administration of karma. Yeah, just as it is stated in the functions here. It says it administers karma, including the registration, regulation, and supervision of the formation, incorporation, management, striking off, and winding up of company. Also, business names, management and removal of names from the register, and the formation, incorporation, and management and dissolution of incorporated trustees. So you will find here that they are like the policing arm of karma. They establish and maintain the company's registry and office in each state of the federation. So okay, now moving to this administrative proceeding committee, sometimes known as the committee itself, I take it as the judiciary part of karma. Sorry, I'm actually giving it this name, but it's what make me understand it better. So I take it as the judiciary arm of karma because certainly it's empowered to resolve disputes or grievances arising from the operation of karma or its regulation, and also it imposes penalties for any kind of contravention. So basically under the administrative committee, we kind of need to know that it is made up of 5 representatives of the operational department of the commission, and also representative of the Federal Ministry of Industrial Trade and Investment. Yeah, like I said, they resolve dispute and grievances. Yeah, and they impose administrative penalties for those that violate the provisions of karma. Okay, I think done this we've done justice to that. Now let's look at the functional classification of companies. It's okay to point out that we have 3 kind of classification of company. We have the ones limited by shares, we also have the ones limited by guarantee, and we have the ones limited by it's unlimited. We have the ones that are unlimited liability. Now let me just say a few to this. When we talk about companies limited by shares, we're talking about companies that issues shares shares. You get? There are companies you find that the members they are liable to the amount they contributed as shares to the company. So in that kind of scenario, now you find out that they are in for business, yeah, and from that shares, the profits that they generate, the dividend, are being sent out to them, you get, as proprietary interest. Let me put it that way. The whole scenario, the whole idea of companies limited by share is that um, every member have a proprietary interest in that firm, which is shares. But a company limited by guarantee, it's where you find these kind of companies are like charitable organizations, more or less like it, because they are kind of set up not for the major interest of making profits, but it is a company. I would like to use, for instance, now, like they did not actually issue out shares for people to buy. People became members of it by guarantee. You get? So we can have, for instance, a sporting association, yeah, a sport association, football club association, that basically it's not for all that, is not all that in quotes for profit making, but kind of they also contribute money. Yeah, they can say, okay, I contribute $1 or $5, all those kind of things. But it's not like it's a shared something. No, it's not like it's a shared something. They do not issue out shares. So that is the basic thing that you should note about it. It shouldn't be confusing. Yeah, it was at first to me, but then kind of I got the concept now. So another difference between limited by shares and limited by guarantees is that you will see at the end of the business name you should see GTE, for instance, and for limited by shares you see something like PLC, yeah, and all those things. Now, unlimited liability partnership, from its name you should know that their liabilities are unlimited. It is just basic sense there. Now let's move on to private company. On that private company, let's check out the characteristics which Kama provides. So in its memorandum of association, it is stated as a private company. Now, memorandum of association here is talking about the constitution of the company. It's talking about what guides the external relations of that company. So in that constitution, it is stated as the private company. Now, in its articles of association, yeah, they will also state that their shares are limited. Yeah, but they can actually give some, let's say, some exceptions. You get? Now let me put it in this sense, just like how Kama said. He said the company shall not, without the consent of all its members, sell assets of a value that is more than 50% of the total value of the company's assets. A member is prohibited from selling his shares in the company to a non-member without first offering those shares to a co-members. And a member or a group of members acting in unison are prohibited from selling or agreeing to sell more than 50% of the shares in the company to a person who is a non-member, unless the latter has offered to buy all of the existing members' interest on the same terms. Now, to me, I find this self-explanatory when you actually read it. Now, for private company, like I said, the minimum membership is 50, not more, not less, and this is excluding the employees, yeah, members of the company. Now, you can actually check out the remaining part of the characteristics of private company. Now, basically, for public company, I just want to state that the pub, like just like you said, public company, the members of public can subscribe to its shares, which is way different for private company. It's restricted. It's like word private. It's not for the public. Yeah, public cannot come to consume their shares. So, and then the name will end with PLC. Now, for small company, it is worthy to note that a small company can actually be a private company, but a private company may not be a small company. You get? I think you need to play the video back to actually listen to it again to know what to, and it will make more sense. So for a small company, the turnover rate is 120 million, and that is the sales. The sales it should make from, like, this is how we know a small company. The sales is making each year is 120 million, and its net assets, yeah, after subtracting its liability, yeah, net assets is still almost, is just like its equity or its capital is is not more than 60 million. Yeah, so you can actually still check out the characteristics of a small company to get more knowledge of it. Yeah, please, if you reached this level, I will so love it that you subscribe, click on the notification bell, and also comment. Yeah, comment. Like I said, this is more or less like a journey that I'm taking towards my ICAN exams in May 2024. And every time I review each chapter that I read, yeah, and it's been fun so far. And to persons that have reached out to me one way or the other trying to encourage me, I appreciate it a lot. Yeah, the goal here is that we will smash ICAN business law exam. That one is certain. Yeah, the confidence is there, and the testimonies are waiting every one of us that is putting in the hard work and diligence. So let's focus on that consistency. Let's also understand that we can't do it alone. Yeah, that's why I'm putting out this information out here. Yeah, we can't do it alone. This can serve as a summary to some persons that don't have time to sit down and read but need something to listen to. Yeah, it can serve as a summary. But then let's talk more reading. Now, promoters. Promoter, just as let me just break down what promoter is. Now, promoter is the person that actually brings up the initial idea of a company. Because I kind of, this was confusing to me at first, but then I later understood what it's talking about. The promoter is someone that, like I say, organizes or co-founds a business. According to what he stated here, he said any person who undertakes to take part in forming a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose, or who, with regard to a proposed or newly formed company, undertakes a part in raising a capital for it. Now, I find this lengthy when I read it at first and confusing, but I actually did more research and I noticed that looking at this scenario here, let's say we have John and Cynthia. We have John and Cynthia. That's two basic names you hear from me. Now, John brought up an idea that what if we have a car that is powered by solar? Looking at it, it will sell in the market and will make massive profits. But if I know that John don't have the money, like he don't have the money currently. Yeah, he don't have the money currently. He just have the idea. Now, John reaches out to Sarah and tells Sarah about the idea. Sorry, tells Cynthia about the idea. Now, Cynthia loves the idea. Yeah, she was impressed by that idea, and she said she's going to support John in organizing the company, yeah, and all that. So in this scenario, you find out that John is actually doing everything necessary to make sure that the company comes to life. Yeah, he is the promoter in this sense. He may not be the person that will run the business or the company at the end, but he's undertaking everything necessary and all activities, every necessary step to make sure that this idea of his comes to reality. You get? So that is the basic concept of who a promoter is. Now the promoters have different duties. Yeah, you have duty of care, duty to account for whatever had happened, yeah, before the incorporation of the business. Duty to he has duty to not make secret profits, yeah, in any transaction with or on or behalf of the company. So he also he has a right to, he can actually sell his property to the company, yeah, but he must disclose it. That is one thing. Duty to disclose. He must disclose it to the company, else his case is oyo. Okay, so let's look at remedies in a nutshell. Let's say, for instance, the promoter has breached his duty. There are certain things that the company can actually do in this regard. The board of directors can actually sue for recovery of those secret profits which he made, or he could sue for damages, compensation, and any other. Yeah, so you can actually check out more content on it in the ICAN study pack. And let me point a few about the pre-incorporation contracts. Now, this pre-incorporation contract, the business was not in existence, so we cannot actually say there was a contract. But then we know that the promoter was acting on behalf of the company, and there may be some agreements that he has made with people before the business was incorporated. Let's say, for instance, he went to a supplier of the key raw material that the company needs, and says, see, when the business starts, this company is going to buy from you, and then the supplier agrees, yeah, and consent and do all those things, and they sign the contract. um After, when the promoter has disclosed this to the board of directors, and the board of directors are okay with it, they can actually ratify that contract he made with the supplier. Ratification means they can agree to the contract. They can agree to contract. But this is, again, if the subscribers, which the members, that is the members of the company, if they all agree to it. If not, John, which is the promoter, will be solely liable to that contract. That's just the catch. Okay, so you can actually, I just gave an overview of what this pre-incorporation contract is. You get, so you can actually check out the content of it. Yeah. Procedure in forming a company. Who form a company? Any two or more persons can form a company. Yeah, but then there are persons too that are disqualified. People of unsound mind, under the age of 18, bankrupts, yeah, a corporate body that is in liquidation. So that's it for that. That's it for that. And there are procedures to it. The procedures, you can actually check that out. Yeah. Okay. Now, documents for incorporation. Before we're talking about partnership, like the document for incorporation or partner. Now we're looking at for company. Okay. You should just, this is how I actually break this down so that I can actually remember it in the exam hall. We always know that for anything incorporation, comma, CAC, they will always ask for memorandum, which is the constitution of the company, and then articles of association, which is something that guides the internal workings of the company. Now, with that, you can actually put that as first document needed. Then every other thing they need to ask is the name of the company. So like the business name of the company is always there, and the registered address. You get, like, those two things to always common, and the style of the business too. So with that in mind, we can actually grasp that 2 points in it. So other things now that we now need to stick to our head is the name and address of the agent. Yeah, if it's the agent that is registering it, and then the particulars of the directors with their consent in the prescribed form. Yeah, so the director is an officer of business, so it will be there, and you can see other things, yeah, which is required for incorporation of a company. Okay, now I've been saying, you've been hearing me say memorandum of association. Now let's talk about it in a nutshell. Memorandum, like stated here, is the constitution of the company. Yeah, what are those things that are needed for it to be called a memorandum? It must have the name of the company, the address of the company, the style of the company, that is its nature. Is it a private or a public company? Yeah, the nature of liability. You get, this is just the constitution that guides the company. Now, the articles of association is just looking at the company's internal relations, how it is regulated. It is that article that regulates it. You get, it's the internal rules that the business have set. You understand? So that's it for that. Now, there are certain times that CAC may refuse to register a company. Yeah, and basically the height of it is if they don't comply with the provisions of CAMA. Yeah, if they don't fully comply, and then if the business is proven to be illegal, or if it's not in compliance with the law of Nigeria, yeah, as to registration and incorporation of company. So let me then end with the consequence of incorporation. Now, when a business is incorporated, we should know that there are certain things that the business assumes. First is corporate personality. Now, with this, now is being distinct from the members. It is separate now. It's a separate person. It's a person on its own. Yeah, from the members of the company. You get. So also, limitation of liability is another thing. because of it is a separate person. Yeah, when obligations are incurred on behalf of the company is directly liable. You get, it is not that the members are all liable. No, although the members of the shareholders may partake in the contribution to settle debts at the end of the process of winding up at a point, but the company is directly the liable to any obligations incurred on behalf of the company. Now, in property, the business can actually buy property or sell property in its own name. It can also be sued, or it can sue in its own name too. You get, so perpetual succession is talking of the fact that when a member dies, yeah, it does not affect the business, it does not affect the going concern of the business. So that's it. When the member dies, the business still continue. Okay, so it can also borrow money in its own name. Okay, it can transfer shares to it, but it depends on the company. It depends on the company, because we also talk about the fact that it can be a guaranteed company. Okay, so lifting of veil of incorporation. Now, there are times that people can actually want to incorporate a company so as to avoid certain things. Like there are certain cases you hear where the company is at the verge of entering, maybe it's not incorporated yet, but a business is at the verge of entering a debt, and then the owner of the company, with that criminal mindset, goes ahead to incorporate that company just so he don't bear full liability the for what he has done. Yeah, just so the liability falls on the business name or the company. You get, so these are some things that people can be tricky about to do. So Karma actually made provisions in this regard. Okay, he said when he discovered that the company has been formed so as to avoid legal obligations, it can, the veil, that's that veil, that covering that he has of being incorporated, can be removed. When a company carries on business with less than the minimum membership of two, that incorporation can be removed. Where the name of the company has been misstated, or the company has been misdescribed on a document. Like for instance, in the situation where an officer of the company issued a bill of exchange on which the name of the company was not properly written, the officer shall be liable for the value of the bill if the company fails to pay it. See, another is fraudulent trading. So there are more that you can actually check out. You get, so we've come to the end of this this chapter. It's been an interesting ride. Yeah, it's been a lengthy and an interesting ride. Very much soon we are going to be attending to questions as to the formation. I'm going to do the same thing I did for the Nigerian legal system. I'm going to try to map out questions specifics to the formation of business organization, but then I will not do it until I'm done with the chapter 3 of this paper, because they have this similarity. Yeah, and they have this flow. You get, so I want to say big thank you to persons that have been following this series, also encouraging me. Yeah, I thank you a lot. I thank you a lot. Like I said again, this is actually a journey to my ICAN business law exam, which will be in May 2024. Yeah, and every time I read a chapter, I do a summary of what I learned, and then if there are researches or confusions I had while reading it, I try to break it down in this video so that you guys may not actually go through that same process of trying to rack your head as to what was said here or what was not said there. You can reach out to me on WhatsApp. My number is on the description tab. You could also comment if there are places where I did not fully explain. I'm also learning. Remember, I'm writing my exams too. You can actually help me. Yeah, you can help me to take note of it, and I also appreciate it a lot. So thank you so much for your time, and I'll catch you in the next chapter.